Greetings everyone. It is no dispute that one of the most shocking and saddening news of this year is the scandal of GISB involving sexual and physical abuse of children. 402 children suspected of abuse from 20 care facilities in Malaysia have been rescued by authorities. This has brought significant public attention to the issue of child sexual offences in our country. The Sexual Offences Against Children Act 2017, which we will refer to as SOACA from now, is a special enactment which aims to provide a comprehensive legal framework to combat sexual offences against children, ensuring stricter penalties for offenders and better protection for the victims. There are specific provisions that protect children from offences relating to child sexual abuse material, child grooming, child sexual assault, and etc. Reports indicate that thousands of children are victims of sexual abuse each year, with less than 5% reported due to prejudice and fear. The enactment of SOACA provides law enforcement to combat with these crimes effectively. In this video, we will share with you, especially if you are a parent, how SOACA protects your children from sexual offences.
Before 2017, child sexual offences were governed by the Penal Code, Child Act 2001 and Domestic Violence Act 1994. While these laws provided some protection, they were inadequate for addressing modern crimes like online grooming and child sexual abuse material. Challenges such as overlapping jurisdiction, lack of specificity, and the inability to address technology-facilitated offences highlighted the need for reform. Upon recognizing this gap, Parliament introduced and swiftly passed the SOACA, a landmark move now reflecting the legislature's urgency to combat rising sexual crimes against children. Before 2017, SOACA's special legislation status allows it to take precedence over general law, making it the primary reference point for handling child sexual offences. This was affirmed in the case of Chan Kok Paul, where the judiciary upheld that general provisions do not derogate from special provisions, reinforcing the SOACA's authority in addressing these specific crimes. Unlike general laws, SOACA is enacted specifically to confront modern challenges such as criminalizing the production, possession, and dissemination of child abuse material, as well as introducing new offences like sexual grooming and non-physical sexual assault. Section 5 to Section 15B of the Sexual Offences Against Children Act details three main groups of offences covered under this act. So let's break it down for easy understanding. SOACA criminalizes the making, producing, or directing of child sexual abuse material under Section 5 and 6, including preparatory acts like gathering resources and planning. Anyone involved in such production is also guilty. For example, in the Muhammad case, the accused who had organized inappropriate photography session with children was convicted under Section 5. Through this, parents must teach their children never to allow strangers to photograph them at any circumstances. Sections 7, 8, and 9 penalize those who use or cause a child to be involved in such material, as well as those who obtain, distribute, or sell it for profit. In Hendra case, the accused solicited explicit content from a child through an online app, and he was thus convicted under Section 8. Section 9 specifically criminalizes distributing such material to a child, while Section 10 extends liability to possession and access of such material, targeting even website administrators who knowingly profit from hosting such materials. Moving on, SOACA also criminalizes child grooming in all stages, from communication to intended exploitation. Section 11 prohibits sexual communication with a child unless for education, scientific, or medical purposes, whereas Section 12 targets grooming by predators who communicate with children to facilitate offences like sexual assault or exploitation, often by pretending to be someone else to gain their trust. Section 13 criminalizes when further steps are taken, such as arranging to meet a child with intent to exploit. These provisions enable proactive intervention and protect children from harm. As we had discussed in the Hendra's case, to avoid what had happened there where the accused befriended and groomed the underage for sexual purposes, parents need to be careful when allowing their child access to technology and devices at an early age, as many predators are looking on online apps all the time, and it is the perfect opportunity for them to groom the child without the parents knowing what is going on in the phone.
Let's talk about third group of offence, which was established in Section 14 to 15B, that relates to physical and non-physical sexual assault on child. Well, first and foremost, Section 14 criminalizes act of physical sexual contact with a child, even through clothing or even short of sexual intercourse. In Ibrahim's case, the accused is a neighbor who drove children to school. He was convicted under these sections for violating private parts of young girls. Additionally, Section 15 addresses on non-physical sexual elements such as gesture, sound, or forcing a child to watch or engage in explicit activities. And in Sangha case, the offender gestured towards a child who was his niece inappropriately, leading to his convictions under these sections. Well, This case highlights the needs for parents to teach children to recognize and report inappropriate behavior, even from trusted individuals. Moreover, Section 15A penalizes using or coercing a child to engage in sexually explicit performance, whether live or recorded, while Sections 15B criminalize sexual extortion, where threats are used to compel a child into explicit act or sharing explicit materials. For instance, as we can see in Lim's case, the predator threatened to release a child explicit photo unless they comply with his demand. And such cases definitely stress the importance for parents to educate children in reporting threats and unusual behavior to authority, especially if they are being forced or being held leverage over. Okay, now that you have basic understanding of the three main group of offense in the SOACA, let us move on to the second part of this discussion. Beyond defining the main group of offense, SOACA incorporates measures aimed at deterrence. Ultimately, one salient feature is the stricter penalties compared to the Penal Code and Child Act, as highlighted in the table shown. This heavier punishment reflects Malaysia's firm stand on crimes involving children. Moreover, this act mandates whipping for serious offence under Section 25 to ensure offenders cannot evade corporal punishment due to age or other mitigating factors that are established under Section 24. Additionally, Section 16 introduced enhanced sentencing for breach of trust, targeting individuals in caregiving or authority roles, such as teachers and guardians. By recognizing their heightened responsibility, this provision deters exploitation by those who entrust with a child's safety. Well, to establish higher accountability, SOACA employs provisions like Illustration B to Section 7, allowing multiple charges for a single act. For example, possession, productions, or distributions of child sexual abuse materials. Besides, Sections 11, subsections 2b use an objective test for sexual communications, simplifying the burden of proof, while Section 20 sets a stringent threshold for defense, making it harder for offences to claim ignorance of the victim's age. These measures close prosecutorial loopholes and ensure offenders face a greater legal burdens. Additionally, SOACA's extraterritorial application under Section 3 further ensure that Malaysian citizens committing offence abroad can still be prosecuted, thus eliminating their chance of escape from this charge. This global reach, combined with harsher penalties, actively discourage potential offenders and reduce recidivism.
Moving on to public responsibility, Section 19 of the SOACA imposes a mandatory reporting obligation on all Malaysians. This section requires individuals to report to the police any commission of a child sexual offence or the intention of someone to commit such an offence. Failure to report or withstanding relevant information constitutes an offence. The purpose of this provision is to ensure the Act's effectiveness by reinforcing the idea that protecting children from sexual offences is a community-wide responsibility. Reporting potential offenders can prevent these crimes, while reporting committed offences ensures offenders are held accountable, preventing further harm. At the National Convention of Protecting Students from Sexual Exploitation, Law and Institutional Reform Minister Azalina Othman Said warned school administrators that failure to report suspected cases of sexual harassment against children could result in a charge under Section 19. She also assured that those who provide information will receive legal protection. Compared with the Child Act, a similar obligation is only on professionals working in child-related environments, but the sentence is heavier. Section 19 of SOACA is more comprehensive as it prescribes a duty on everyone regardless of profession. Additionally, Section 21 provides that individuals who abet or encourage the commission of child sexual offences will face the same punishment as the offender, as though they committed the crime themselves. This ensures that accomplices are held equally accountable, preventing individuals from facilitating or supporting such offences. Section 23, on the other hand, imposes corporate liability, holding directors, managers, and other officers accountable for the wrongdoing of their employees unless they can prove the offence occurred without their knowledge, consent, or connivance, and they exercise all due diligence to prevent these offences. This provision is particularly relevant in the GISB scandal, where top executives were arrested and corporate leaders were remanded for investigations into their roles in the systematic abuse. By extending liability to corporate leadership, this section ensures that organizations take proactive measures to prevent child sexual offences. Together, these provisions, mandatory reporting, accountability for abetment, and corporate liability, underscore the shared responsibility of the public and corporations in safeguarding children and preventing sexual offences.
SOACA enhances the power of relevant authorities, particularly in securing evidence against offenders. Section 22 addresses the role of agent provocators in the context of child sexual offences. An agent provocator, an individual involved in attempting, encouraging, or conspiring to commit such offences, will not automatically be deemed as an unreliable witness, provided their actions are aimed at securing evidence against an actual or potential offender. This ensures that evidence obtained through the undercover operation remains admissible in court. Well, this provision is primarily designed to be used by law enforcement agencies and child protection services. This empowers them to undertake undercover operations in cases where corroborating evidence might otherwise be difficult to obtain. By validating the credibility of agent provocators, authorities can strengthen their investigation and ensure offenders are brought to justice. This significantly enhances the ability of relevant bodies to protect children from sexual offences. For instance, relating back to child grooming offences, Section 22 works in tandem with Section 12, Subsection 2 to enable authorities to make preemptive steps against offenders before they can sexually assault a child. Evidence such as inappropriate messages or attempts to establish a relationship with a child can signal intent, allowing the police to intervene early. If an indication of offender's intent to sexually abuse is present, law enforcement can bring the individual into custody, even before the physical harm occurs. These enhanced powers are critical for preventing further harm to children. By equipping authorities with tools to identify and act against potential offenders, SOACA ensures that children are protected from both immediate and future risks of sexual exploitations.
Let us now examine the post-commission measures provided under SOACA, which address the aftermath of a conviction. These measures aim to protect children, rehabilitate offenders, and reduce likelihood of reoffending, thereby safeguarding the community. First, Section 26 empowers court to order offenders to undergo rehabilitative counselling during their imprisonment. This counselling, supervised by prison management authorities, help offenders recognize the harm they have caused and work towards behavioral change. Rehabilitation is emphasized as a critical component of preventing future offences. Section 27 further ensures post-release safety by mandating that courts direct police supervision of offenders for a period ranging from 1 to 3 years. This monitoring allows authorities to intervene if necessary, thereby reducing the risk of reoffending. For instance, in the case of Fadzil, a teacher convicted of multiple sexual offences against his students was ordered to undergo rehabilitative counselling and post-release supervision. This demonstrates how these provisions work together to address the root causes of offending behaviour while prioritizing public safety. In addition to rehabilitation and supervision, SOACA provides avenues for victim compensation under 26A and 26B. Section 26A empowers courts to order offenders or their parents or guardian, if the offender is a child, to pay compensation to the victim. This compensation aims to address the harm caused, taking into account factors such as the seriousness of the offence, physical and emotional damage, and expenses incurred. In cases where the victims has passed away, the compensation is directed to their representative. Importantly, compensation orders take precedence over prosecution costs, and victims retain the right to seek further remedies through civil claims. To ensure enforceability, Section 26B establishes mechanism for payment. Offenders may pay in installment or through property seizure. If the offender fails to pay, imprisonment may be imposed as a substitute with duration ranging from 1 to 6 months, depending on the amount owed. Additionally, courts may allocate cash found on the offenders at the time of the detention, provided this does not harm their dependents. This provision ensures victims receive the compensation owed while holding offenders accountable even in cases of financial difficulty. In summary, these post-commission measures emphasize SOACA's dual approach of justice and protection. By focusing on rehabilitation, monitoring, and victim compensation, the Act demonstrates its commitment to long-term safeguarding of children and community.
In essence, the SOACA not only aggravates sexual offences against children, it also incorporates a comprehensive framework of measures aimed at prevention, deterrence, accountability, and rehabilitation. These provisions work together to create a safer environment for children, addressing both the immediate and long-term challenges of combating child sexual offences. We hope that every parent, even if you are not one, watching this video now has a clearer understanding of the SOACA and, more importantly, how it protects the future generations of our country. From its stricter penalties and mandatory reporting obligations to enhanced law enforcement powers and post-commission measures, SOACA demonstrates Malaysia's firm commitment to prioritizing children's welfare and safety. Thank you for joining us in exploring this critical piece of legislation. Let us work together to build a safer and brighter future for our children.